itself, because that will give it's I made it its complete neutral chart, not for whether for 25 or whatever is there. If Lordship, before seeing in detail, if Lordship kindly take the next page, the crux of it, if I begin with that, the main differences, the 6. The written examination, earlier it was 55%. Now there is a 5 marks more, 60. The non-written component, earlier it was more, 45%. Now it has become 40. Now this maximum advantage from academics, this I will show from the first page itself. Now one interesting aspect, interview shortlisting for 100. Earlier it used to be calling 140.
Yes.
Now it is 160. Now Lordship kindly take the first page itself. First 55-60 I have already said. Now another major changes in the academic qualification. Earlier the marking was 35 in 2016. Now that has been reduced to 10. Now, prior teaching experience, earlier it was nil. Now it is 10, maximum 10 marks. Now personality test interview, earlier it was 10, now also 10, same. The lecture demonstration, earlier it was not there, now it is there. So if Lordship make it a two broad category of written and non-written component, Lordship will see that in the written component there is a hike. Because why I want to little emphasis on the written, because written is a completely level playing field, and the non-written is something whatever someone has done past, whether academically and others. Now regarding this kindly see, my lord, Roman 3, the which were the things which were there in 16. In 16, my lord, there are 3 buckets like 25, but that buckets was supposed to be filled up by Madhyamik, then higher secondary, then graduation, B.Ed, and total was 35. Now if Lordship kindly compare it, next page, this is not sorry, that is not next page, because there that I placed it, it is not here. Now it is only 10 marks, 3 buckets, and based on it's a graduation or post graduation, whichever is higher. So a major shift is that Madhyamik, higher secondary, and the marking for the B.Ed, which were all out, which were there in 16. That's the major shift. So therefore that 35 marks was there, now it has come down to 10. Prior teaching experience, that I need not say. Now based on that, if Lordship kindly take the Roman 7, that what I intended to submit. First is under the 16 rules, written examination carried 55 marks, under the 25, 60 marks. So for a fresher, the most powerful component is the written test. That's a general statement. So this is stronger than under the 16 rule. Why I was trying to, my lord, also focus on this, because their entire focus is on somehow disturbing the equality by 10, because regarding educational qualifications others, this is not the grievance that they have agitated, though I have given whatever is the plus minuses or the changes, but their grievance is on that. Now if Lordship look at that grievance, that today you don't get 10 because you don't have experience, because you are a fresher, one immediate reply could be, yes, you don't get that, but you also have 5 more if you are a better student, because of the competition. That's the written marks. Just I would say, if someone says that, there is a possibility of the opposite way of looking it also. Now non-written marks have actually reduced. Their under 16 rules, non-written components total 45 marks, academic 35, and personality 10. Under 25, this non-written components totally now only 40 marks, educational 10, experience 10, interview 10, and lecture demonstration 10. So this is, I would say, the major change. Now, 2025 rules do not increase discretion or arbitrariness. That I tend to say that it's not that interview marks is increased, where a subjective satisfactions of someone or there is a possibility of arbitrariness, that is not there. Interviews, it remains same. C, experience marks are strictly capped at 10%. This part I am not making submission because this I already made submission. Now D, freshers compete on more written centric model, which I was trying to say that the non-written component got reduced little and written component got increased little. So therefore it is more. Now E is that shortlisting part, that now because of 100 it becomes 160, so chances
of being shortlisted increases.
So therefore if a question is put to me, is it different, I would say yes, substantially 25 rules are different. It's not identical at all, but that substantial difference, if I try to look at from a neutral point of view, is towards, the answer is F. I've just put it in writing, F. The classification is valid under Article 14 if there is Roman 1 an intelligible differentia, and number 2 a rational nexus with the object sought to be achieved. Now intelligible differentia, the candidates with teaching experience form a distinct class from freshers. So therefore this is clear, they are different. Now question is whether nexus, the nexus part, teaching experience improves classroom management and pedagogical skills are direct link to the object of selecting effective teachers. But it would be very difficult to prove it, but that's the
admittedly experience matters.
Yes, but that's I'm saying that for that I may not be able to prove by any tangible thing, but that's something which most of us we recognize it. Now both limbs are satisfied, and then I just put it that the 2025 rules are not harsh to freshers. The written examination has become more dominant, non-written component has been reduced, and the experience criteria is strictly capped at 10. The same ceiling as educational qualification can be entirely neutralized by performing well in the written exam. That's a stiffer part for the freshers, that you have to be better students, not everyone. The interview shortlisting ratio has been widened, so therefore a better opportunity to reach the interview stage. So that's the plus for the freshers. So classification satisfy both the limbs, that's the nexus part and the intelligible differentia. And consequently, the allocation of 10 marks of prior teaching experience under 25 rules, that was my respectful submission. That so therefore one sentence, yes, it is different. Substantial difference is there, but that difference is I would say tweak, which I would say gives more importance to experience, which can be said to be synonymously a life skill and more intelligent, better students. Well, there was one specific query. There was a specific query by your lordship. It was not to me. To there was a specific query to Mr. Mitro. Lordships made the query from the Honorable Supreme Court, specific directions that it will not give them any advantage. Well, I was reading that, so I thought there was an interpretations possible. So I just thought that I should make that submissions. 3-4 pages.
এখনো দেয়নি দিচ্ছে।
একটু দিয়ে দিবি এটা মতো পেজটা বলবে। দেখে দাও, দেখে দাও।
রাহুলের অপোজিশন 4টে আছে একসাথে।
একটা তোমারটা দাও।
না এটা না, মানে ভলিউমে করে ফাইল করতে হয়। দিস ওয়ান পুরোটাই
এটাই হ্যাঁ, পেজ 229টা দেখে নিন, যে ভলিউমটা 229। কোন ভলিউমে আছে 229টা? ভলিউমটা অ্যাকচুয়ালি আমি সফট কপিতে ইউজ করছি, তো আমার কাছে মানে since I am using the entire PDF copy, for me it is
Easier.
no, not easier, it is difficult, because in fact there was a thing, this I am seeing in a one dimensional less. When we touch this book, we are in the 3 dimension, and I think connection with the memory and the brain is much better. I say that in the entire PDF I don't have a volume, so that's why I was trying to understand. The page number is 229.
Yes.
And Lordship's query was on page 230, 17-4 order. Because this, well, I have observed that there are 2-3 occasions Lordship wanted to know this, that we clarify, Lordship has got, we clarify that this order shall not be read as conferring any special right or advantage on the aforesaid teachers insofar as fresh recruitment process is concerned. Therefore, this 17-4 order clarifies that it cannot give any special advantage. So I was, because apparently it is very much a negative point if I appear for these candidates who appeared. So I was trying to understand what exactly the order says. So the order basically, may I just first say, thereafter I will show. After this Boishakhi judgment, state filed an MA saying that 1, 2, 3, 4 reasons kindly allow the assistant teachers to continue, just only for that. And that was the prayer. Just for a look, this was the prayer. The exact prayer was, permit the appointees not found to be tainted to continue service till the end of the academic, because they were in a complete mess, the state, how they can run the school. So that was their prayer. In that context, first part was, Lordship, kindly see that, if kindly take the ordering portion, first paragraph. We are inclined to accept the prayer made in the present application, so far as it relates to assistant teacher for classes 9, 10 and 11, 12, not found to be tainted, subject to the following conditions. The condition number 1 was the advertisement to be made. Condition number 2 was the examination and the entire recruitment process shall be completed by 31st 12. Condition number 3, Board of Secondary Education and West Bengal Centers shall file their respective affidavits. Then, board. So let us not go that technicalities. My learned friend was correcting me that this application was made by the board.
Whoever. No, yes.
I say that it makes the same thing. Ultimately, it's the order of the Honorable Supreme Court. 4, in case the advertisement is not published by 31st May and the affidavits are not filed by that date, appropriate orders will be passed by this court, including imposition of cost and vacating of the present order. Vacating of the present order means first line of the order, that allowing the prayer filed in the MA. After that, this is the importance. So in the context of 17th April to December, the continuance of the teachers, now Lordship read, we clarify that this order shall not be read as conferring any special right or advantage on the aforesaid teachers insofar as the fresh recruitment process is concerned. Meaning thereby, yes, Honorable Supreme Court are allowing the teachers to continue from April to December. But that continuance, to my understanding, cannot be counted in any form, not even in the form of an experience, not even in any other form that I was there, any kind of right, nothing. So therefore, this word, we clarify that this order, therefore this order of allowing, it will not give any special right or advantage. This advantage means this continuance after 17/4/2025 up to this
31st.
December.
Hmm.
This has got nothing to do with the past experience of the untainted or not specifically found to be tainted. How that can be also found, consistency, Lordship might see. Kindly take page 376. That is in the third volume. Another order of the Honorable Supreme Court.
Yes.
This is an order dated 29th of August. So on 29th of August, in fact, I would be relying on just the order passed on 21/8, but that is quoted here. That's why I'm showing the one document. 376, kindly see. By order dated 21/8/25, passed in SLP number such and such, this court directed. Well, this is the order 21. We direct that in the meanwhile, well, this is important, all selected and appointed. It is not for everyone. It is not for all participating. Untainted candidates who were permitted to continue in service. That is, this permission was based on 17/4. I just placed. Till 31/12/25 shall be allowed to participate in the fresh selection process without insisting upon their complying with the newly introduced eligibility criteria of securing 50%. Now that other part I am not going. I am only on these two parts. 17/4, the Honorable Supreme Court did not allow this continuance to non-teaching staff. Supreme Court only allowed it for the teaching staff, 9, 10, 11, 12. And this 21/8 order, this further relaxes, not for everyone, but for selected and appointed plus untainted. It's not that whoever participated in 16, they are going to get the same benefit. In that light, if Lordship kindly take it, the same thing, the order passed in the review of Boishaki by the Honorable page 502. Sorry.
Fourth volume. Volume 4.
Yeah, page 502, this is the order. The order starts from 507. 7 naki eta dekho to. My 2.
501 it
Five,
starts.
Lordship is saying 501 is the last page.
It's the first page. It starts with order.
Yes, but that one. So kindly come to this 501 is the order passed in review. Kindly come to 502.
Yes.
502, my lord, somewhat after 10 lines.
Yes.
Little right hand side, however the interest.
Yes. Yes.
However the interest of the, kindly mark again, the same thing. Appointed candidates who were untainted were sought to be protected to the greatest extent possible, as is evident from the concluding paragraphs of the judgment. No doubt, invalidation of such untainted appointments would lead to heartburn and anguish, which the court was fully conscious of. But protecting the purity of selection process is paramount and necessarily has to be given the highest priority. Last but not the least, the adverse remark made against the authorities concerned who were wholly, next word I am on, wholly and solely, because that's what I'm saying, institutional fraud minus the tainted, not attached by the Supreme Court also with us, wholly and solely responsible for this entire imbroglio, adversely affecting the lives of thousands of candidates. Untainted and tainted were fully warranted and justified. And the last is Lordship's, this 2611, that's the last order when it was ultimately sent before your Lordship. This is volume 3, page 391.
Yes.
Kindly see, my lord, here the first two paragraphs I am not placing because it's not necessary for the purpose that I am saying. From the second page, it would be open, but that is also not necessary. After that, the High Court shall, however, ensure that none of the tainted, this is also not necessary because this is now well known and Lordship is doing it. Kindly take the next page, my lord. This starts from the High Court shall examine the matters. 392. 392.
Yes.
The High Court shall examine the matters uninfluenced by any of the observations on merits made by this court in the orders passed after decisions in Boishakhi. And next, this is important. The High Court shall also be mindful of the fact that the untainted candidates in the past selection, this past selection is not the 16. This past selection is for who were allowed by the court based on that 17-4 order. In the past selections were allowed to sit for the selection test to be held afresh, and their candidature cannot be adversely affected. Because initially, my lord, I had a feeling that this past selection refers to 2016.
Is it not?
May I read? Initially, a couple of times I thought that exactly that. May I read? Because that was my impression. The High Court shall also be mindful of the fact that the untainted candidates in the past selections were allowed to sit. Kindly mark the word allowed. The Supreme Court did not allow everyone to sit. Supreme Court allowed it only for the untainted persons. And by an order of the Honorable Supreme Court, the Honorable Supreme Court also relaxed certain conditions for those candidates who were untainted but appointed. Because the circle is more. Circle is wet list, circle is participating, but from the bigger circle, Supreme Court only chose this benefit to be given to appointed untainted. Now, therefore, the word allowing may not have any meaning if Lordship reads it of 16, because in 16, no question of allowing anyone. Everyone was there. So, in that context, if Lordship read it, the High Court shall also be mindful of the fact that the untainted candidates in the past selections were allowed to sit for, because they were allowed just because this order was after Supreme Court allowed it, then they also sat, they could sit it after that relaxation for the selection test to be held afresh, and their candidature cannot be adversely affected by application of new rules. In any case, well, I would be making these submissions. My first submission before your lordship is thinking of there is a possibility of reading it otherwise. But there is a possibility. I don't say that there is no possibility. But then lordship has to somehow drop the word allowed. Well, I also read that.
Why? If we do not drop, then what happens?
If lordship doesn't drop that, then it becomes like this, that the High Court shall also be mindful of the fact that the untainted candidates in the past selection were allowed to sit. Now question is, it is were allowed to sit is an adjective kind of, it's a character.
We're allowed to sit by virtue of the order passed on 3rd of April. It has to be
Yes.
read.
Yes.
If
Yes.
you read it that way,
Yes.
then it's the
Yes.
same.
Yes. I want to read in that way. That by 3rd April, they were allowed to sit, and relaxation was not given to everyone. Relaxation was given, lordship has seen in the previous order, those who were appointed lost their job and they are untainted, not everyone. So therefore they were allowed to sit. So far as if lordship reads it, because I was trying to understand, because in an interpretation, my lord, in fact, every time if someone reads, leave 2-3 days, after that he reads, anyone might have a different interpretations. But as on today, my lord, my interpretation is tilted towards the fact of allowing by the Honorable Supreme Court, and therefore this past selection is really not referring to the selection of 2016, but that selection where it is because of the Honorable Supreme Court, some persons could get a chance. That's in act of allowing happened. So I would make an interpretation in this way, that the Honorable Supreme Court wanted couple of things which are required to be taken into considerations by your lordships. Thing number one, it is not the orders after the main order. It is the main order, that is the 3rd April's Boishakhi's order, not the subsequent order. But even if lordships look at the subsequent order, that 17-4, where lordship has specifically asked question, that no advantage, that advantage was from April to 31st December, not the advantage of the for entire 5 years or whatever number of years. In any case, this order, I would say that the Honorable Supreme Court, all that wanted, that we have allowed some candidates, and while allowing that candidates, we have also relaxed certain conditions, despite the rule requiring otherwise. Lordships need to just consider that. I put it that only. Therefore,
The commission ought not to do anything so that the candidates who have been allowed to be permitted to sit in the fresh selection gets debarred or becomes ineligible for participating.
I exactly this. Whoever Honorable Supreme Court has allowed, lordships be required to just take into account that. It's not that the Honorable Supreme Court has in any way say that it has to be in this direction or that direction. Thus, take note that this is we have allowed. That's all. So therefore, if there is a kind of if lordship, if I go back to that 17-4 observations, because this was an quite submissions showing 17-4, that is at page 230, that we clarify this order shall not be read as conferring any special right and advantage. So if I can sum up this submission, this order in the context of a temporary continuance and temporary continuance only. And this order has got nothing to do with whether in the rule a prior teaching experience can be said to be some constitutionally invalid advantage being given to others. That's not even the, I would say, context or anyway intended by the Honorable Supreme Court. That's, I thought I should, this is my answer to that. Now, my lord, I would go to the rule itself that possibly Lordship is seeing the copy of the rule from separate 2025 rule. No, I have the copy, but Lordship must be
I have
from the
marked
day one.
somewhere.
Lordship was
marking it.
Yes.
এটা রেখে দিন তো।
Page number 346.
Because the marking pages, my lord, if that is not found, I think we would lose track actually. And there lies, as I often say, there lies, my lord, in three-dimensional. For an example, I can, like this page, I know it, what is the middle of it. So
Exactly.
I know it is not going to be a very heavy document. So therefore, even if I am partially blind, I can come somehow the middle of it. But if it is in the lesser dimensions, that now in the iPad, there, whether it is 50 pages or it is a 500 pages, now I don't know.
Yes, the rules.
Yes, rules. But on the rule point, there are three issues. Issue number one is whether prior teaching experience itself is unconstitutional and violative of Article 14 or not. Now, some
It's been argued.
exactly that's
elaborately.
exactly that's what I was about to say, that this issue has substantially been argued, and I also made some submissions. So I don't want to say anything on that. So I just wanted to say what is that, and I would make submissions what is left over already. Now the other, there are two issues, that assuming that this is valid, if it is valid, then interpretation is always open. Then it is in accordance with the rule itself. Now there are two possible interpretations from two sides. The one side, that the petitioner sides are of the opinion that the rule,
Freshers.
yes, freshers, I put it freshers, of course, they feel that the rule says it should be included before the interview list is prepared. Whereas that we who are not the freshers, our interpretation is no, it should be
It's just the opposite. They want it at the time of final merit list, and you want it prior to the
yes, sorry.
interview.
They wanted that it should be done at the end. Now we say that
it should be done now.
It should be done now. Now my answer to what the rule says. Well, I would say from two stages. I would say if the rule becomes intra vires, which is the assumption now, then whatever the rule says, even if, well, sometimes it rule might look good, it might give somehow, we might think there is a better way of doing it, but if the rule itself is that so, then it has to be done in accordance with the rule itself. So my endeavor would be that rule says it should be included prior to preparing this interview list. Why I am saying so? I am saying so because of the two reasons. My reason number one is there is a substantive provision in the rule which says that interview list should be made on the basis of what? Number one. Number two, that substantive rules also refers about schedule which has a sequence and the buckets. And number three, same substantive rule with a different provisions also addresses where the merit list has to be made. Therefore, interview list and the merit list being completely two different things operating separately by the substantive provisions, there any stretching of interpretations based on the interpretational clause may not be proper. May I just show this and I will straightway go to the judgment on this my proposition. I say that the substantive provisions, I said the substantive provision is, kindly take 11 Roman 8.
Yes.
The Central Commission shall prepare and publish in its website a preliminary list with details of candidates to be called for interview. So therefore, this is clear, to be called for interview, subject to verification of credentials and eligibility category wise, on the basis of, now this is the bone of contention, on the basis of preliminary merit score as defined in Rule 2(1)K and K alone. Therefore, my respectful interpretation would be 11(8) is an absolute clarity how this list for interview has to be made. It says that it has to be made on the basis of the preliminary merit score. I would say, so therefore, it has three pillars. Pillar number 1, for what purpose? So answer is the purpose is the interview. The pillar number 2, on what basis? The basis is preliminary merit score. And pillar number 3, it refers to which? Then it refers to Rule 2(1)K. Now this substantive provision, when Lordship look at with the schedule itself, Lordship gets the sequence. Kindly take my schedule 2. So schedule 2, the sequence is number 1, written examination. This has taken place. So it was in the sequence, it is number 1. Number 2 is the academics that I have referred as a bucket. Now educational qualification, it is not number 3. It is something, a component within the bucket of the academics. And there, my lord, this marking, and that is small a, and then small b. So therefore, kindly see thereafter number 3. So sequence is number 1 equals to written examination, number 2 equals to accumulations of these under small a and small b, number 3 equals to oral interview, for which a list has to be prepared, and number 4 equals to lecture demonstration. So therefore, under schedule 2, this sequence, it clearly matches and very much in sync with the definition as well as the substantive provisions. Now, only problem, if I can use the word, only problem or the point which can be said is that in that case, what meaning I give to the definition of the merit list, because that can be one of the very reasonable submissions. Lordship, may kindly take the definition of merit list. Because that is, this definition is that their entire, if I can use the word, entire oxygen for demonstrating that it should be post, not pre. My lord, my first submission is the stage that Lordship is interpreting is whether it is pre or post for interview list. Substantive provision does not refer for anything of the merit list at all. Sequence also gives a clear clarity how it is to be done. Now in that context, if I read merit list, in respect of SLST, such and such means In case of posts, a list of candidates prepared category-wise on the basis of merit, which shall mean, in addition to what has been stated in Rule 21K, marks obtained in oral interview, lecture demonstration, and prior teaching experience, and shall not include all the, this is not relevant. It doesn't talk about the sequence first. It's like, what is a merit list? So it gives a definition of merit list, whatever has been said in addition, because ultimately when the merit list is to be there, that will contain everything, because that will come later on. If I read it once more, my lord, for my understanding, I would read this way. First, merit list definition does not say anything regarding how to prepare the interview list, number one. Number two, it says that merit list in respect of SLST such and such means, in case of post, a list of candidates prepared category-wise on the basis of merit. Kindly pause for one moment. So therefore, merit list simply means whatever is prepared on the basis of merit. Now, pausing for a moment, if Lordship have a comma here. Now, what is merit? If I answer in this way metaphorically, merit is A to Z. Instead of saying A to Z, they have said it means, it shall mean, in addition to what has been stated, because it is stated about the interview list in Rule 21K, marks obtained in oral interview, lecture demonstration, and prior teaching experience. Now, this is the troubling part. This is the troubling part, that and shall include all the eligible candidates. So that means, kindly look at this point of view.
Keeping in mind the submission of the petitioners that if prior teaching experience was not mentioned in the interview list, it has been mentioned for the first time in the merit list. So it should be taken up for consideration at the time of preparation of the merit list. Otherwise, you have to give benefit twice. In the interview list stage also, you are giving the prior teaching experience marks, as well as in the merit list stage also you are giving.
But that is, firstly,
Cannot be.
that is it cannot be, because then this sequence in the schedule has to be broken. It cannot be. One of the, in my understanding, harmonious way of looking at it is this, that for if I go to schedule, then Lordship will get it. Schedule. Okay. Mala, this is one rule under the schedule, also for 9-10, also for 11-12, and also for upper primary. Now in upper primary, in the sequence, the prior teaching experience comes last. So therefore, it is like one rule which has thought to be different for different sectors. I'm not for the time being on right or wrong. All I say that what the rule itself. So therefore, for A and B, that is for 19 and 11-12, there is a one stream which is pre. If Lordship kindly have a look at the sequence in upper primary under C, kindly come to schedule. Schedule, there are, my lord, three, one capital A, capital B, and capital C. Kindly take capital C.
Yes.
Capital C, selection to the post of assistant teacher for upper primary level. Lordship need not read. Kindly straight away come. Kindly see the sequence. Number one, academic score. Number two, TATE weightage, which is the different for them. Number 3, written examination. Number 4, oral interview. Number 5, lecture demonstration. And number 6. Therefore, the rule it is one, which is trying to give some definitions for 2 separate categories. Keeping that in mind, if lordships kindly come to the definition itself. Kindly come, my lord. Now, here is the role of rule 2.1 itself. That in the rules, unless the context otherwise requires. Therefore, my humble submission before lordship would be this. This is one rule for 2 different categories. I would say 3 different categories. Under 3 different categories, they have chosen to go for 2 categories in one directions and 1 category in a separate directions. But they have chosen to give one definition for everyone. So while giving the definition of the merit, all they wanted to say merit equals to A to Z. Meaning thereby, merit means whatever we have said before plus ABCD which are applicable. In case there is a conflict, the answer lies, lordships are required to see first whether, because for every definition it may not be there. First is this definition has to be used unless the context otherwise requires. Therefore, if the context is, here the context is the SSC is preparing the interview list, what they are required to do. My humble answer would be they are required to see what is the rule and they are required to follow that. And the answer is for that, my lord, the rule 11, that is to be followed. And once that is followed, lordship doesn't find the definition of merit coming into play. Now, one apprehension may come. Does it mean that they will get again marks? My answer would be no. Why it is no? Because the sequence and the schedule has to be followed, number 1. Number 2, even if there is a conflict language-wise or otherwise, then it is the substantive provision which is required to be followed. And for merit, if lordships kindly once more come to 11.8 equals to today's situations. That's the interview list, 11.8. Now, there is a separate situation also for the merit, that is Romans 16.
Yes.
Kindly see post-interview. After interview, the interview board shall forward a detailed report to the Central Commission, which shall form the interview list, and on the basis of the report of the interview board, prepare, publish a merit list, categorized on the basis of the merit as per Schedule 2. The moment, kindly my lord, see this part, as per Schedule 2, I would read this way, as per Schedule 2, A, B or C. The moment it is A, B and C, there is no scope of going differently or double, because A has single, B has single and C has single, but differently. For A and B, it is similar way. For C, it is last. Well, to that, there is a judgment. Judgment. Well, at first judgment, which one? Upper. This is, yes, 1985, SCC online, Bombay, 256. I shall be relying only 2 paragraphs, 22 and 23. This is for the purpose, unless context otherwise says. According to my submissions, it doesn't. But in case, my lord, there is any iota of of conflict being there, then my lord, the interpretation is this. Paragraph 22. Francis Benyon in his treatise Statutory Interpretations 1984 such and such page, whether the defining enactment says so or not, a definition applies only where the contrary intention does not appear. I am only on that part. This is because the legislation is always free to display a definition with the disapply. Correct. Because the legislator is always free to disapply a definition, whether expressly or by implication. Lordship need not read the others. Kindly come to 23. It is precisely to meet such contingency, the definition clauses invariably limit the scope of the definition by using the expression unless the subject or context otherwise requires, or some such qualifying words as laid down in such and such. The interpretations clause should not be understood as requiring, now this is the point, it should not be understood as requiring extended meaning in all circumstances, for the definition clause itself says unless the context otherwise requires. However, even where such an expression is employed, it is only where the contrary intention appears from the context that the definition clause may be given a go by and the word understood as is understood in common parlance. But then, as stated above, when the definition, that's not. In this context, Lordship will not find a different intention is appearing in Schedule 2 or in Rule 11. Absence of merit list in Rule 11 is the clarity to follow Schedule 2 sequentially. Well, next is 1980, 1 SCC 321. Only one paragraph, paragraph 24. Paragraph 24. A definition clause does not necessarily in any statute apply in all possible contexts in which the word which is defined may be found therein. The opening clause of Section 2 of the Principal Act itself suggests that any expressions defined in that section should be given the meaning assigned to therein unless the context otherwise requires. Well, there is one more judgment. Okay, two more. Motu. Well, 9. Well, there is one judgment. This is the Vanguard fire. This is not reported. It is taken from the Honorable Supreme Court's website. This is a copy. Paragraph number 5. Sorry, this is not paragraph because there is no paragraph number. There is page 5. SLP number to give. Well, from it is well settled that it is there is one first paragraph. Lordship may skip. Thereafter another. It's referred about section 33. Lordship may skip.
It is well settled.
Yes. It is well settled that all statutory definitions or abbreviations must be read subject to the qualifications variously expressed in the definition clauses which created them. And it may be that even where the definition is exhaustive, inasmuch as the word defined is said to mean a certain thing, it is possible for the word to have a somehow different meaning in different sections of the act, depending upon the subject or the context. That is why all definitions in statute generally begin with the qualifying words similar to the word used in the present case, namely, unless there is anything repugnant in the subject or context. Therefore, in finding out the meaning of the word, here context was insurer, in various sections of the act, the meaning to be ordinarily given to it, it is that given in the definition clause. But this is not inflexible, and there may be sections in the act where the meaning may have to be departed from on account of the subject or context in which the word has been used, and that will be given effect to the opening sentence in the definition sections, namely unless, well, that part. So the last one is 1997 to SCC 53, paragraph 12 and 13. Paragraph 12 and 13. Where the definition or expression as in the instant case is preceded by the words unless the context otherwise requires, the said definition set out in the section is to be applied and given effect to. But this rule, which is the normal rule, may be departed from if there be something in the context to show that the definition could not be applied. Why I'm making these submissions? Because my understanding is the merit list equals to A to Z, all, no repeat. By stretching the definition of merit, if an interpretation is sought to be made that it would make a twice prior teaching experience, lordships can very well, even if there is a conflict, lordships can very well take that interpretations, saying that I would not go only with the definition of merit itself. I will take merit as whatever has been said above plus whatever is left over. That is, merit equals to all and the preliminary equals to whatever said before that. And 13 is, this court in such and such case, while considering the definition clause of the act which is under our consideration held, a definition clause does not necessarily in any statute apply in all possible context in which the word which is defined may be found therein. The opening clause of section 2 such and itself suggests this is the same thing which has been said. Well, on this topic there is no other judgments. Now I shall be placing the judgment on the directly on prior teaching experience point. My first judgment that it is valid. First is Sachidwala.
Quite a few has been referred, possibly in Orunima, Paul.
Which one?
This prior teaching experience is permissible. It is perfectly done. No issues.
Well, yes,
The
but
others have also referred to.
yes, division. What I am trying to address it that because I thought that I would be ending with that this rule was challenged. The point of prior teaching experience was also canvassed before the honorable single judge. The fact of challenge of the rule was given up before the honorable division bench. Prior teaching experience was canvassed. The honorable division bench also there is one detailed paragraph that it is okay. Experience is something intelligible differentia is there, that is expressed there, and ultimately it's not that it was interfered by the honorable Supreme Court. But I was also making an effort, assuming nothing is there. I was, because it's not an interim purpose. Lordship is going to deliver a final judgment. Of course, that's one of the good points in our favor. Leaving aside that also, when Lordships look at the issue as if it is absolutely a fresh issue which has not been touched by any court before at all, even then, there is an every possibility that Lordship might echo with the same saying that, Malady, I would put it in this simple words, that once there is a recognition that experience is different, the fact of some weightage being given to that experience, irrespective of the fact that that causes the competition becomes harsher for some others, or it becomes tougher for the freshers, Lordships may choose not to interfere with it in the light of the Article 1416 by saying that there are differences. Some people have more experiences, therefore they get weightage. You become a better student and you fight in the dominant factor of this. On that context, yes, Lordship is absolutely right. In Orunima matter, division bench have said so. I have that judgment also. But this is the judgment where 2017 11 SSC page 421. On past service point, straightway paragraph number 21. The
Which paragraph?
yes,
is it?
paragraph
21.
paragraph 21.
Yes.
Before that, for lit, but I think madam, I'm trying to go to the exact paragraph. So therefore, paragraph 21, the first respondent who was a party to the settlement recorded by the High Court in its order dated such and such could not be permitted to raise the question of enforceability of the settlement, more particularly when all that the appellant seeks is only weightage for the past service of its members, which the first respondent agreed. In principle, I'm on the in principle point, to give to similarly situated persons working with other departments. The members of the appellant union have been working with the first respondent for long periods, period varying from such and such. Whether such employment was regular or irregular in law is a different matter. Well, because there was one of the submissions from petitioners was the Honorable Supreme Court declared it to be void. Does it mean that our act of teaching, or if I can say this, does it mean also that our entire experience also becomes void? My first answer is the Honorable Supreme Court have actually, while dealing with untainted, with two categories, kept even the past service who had an old job and allowed us to participate. And in that context, state chose to make a rule to give an weightage to all the persons whoever has got the past experience. In my understanding, my lord, that does not violate at all. And next judgment is 2024 SCC online SC 3540. It was by Justice Dotto and Justice Mahadevan. Paragraph 29. But the context can be found from, I'm not reading all paragraphs, 25, 26, 28. But ultimately, Lordship will see that very short, as we are applied to the constitutional mandate prescribed in Article 14 and 16, read with a preambular promise of securing social justice, we hold that non-grant of mark for experience to the first respondent was not proper and legal. So therefore, there was an affirmation. Next, whatever. But this is, Lordship also kindly take 28 also. In this case, for the foregoing reasons, refusal to award any mark for experience to the first respondent would go against the grain of the constitutional duty of ensuring equality and securing social justice for the deprived. My lord, next judgment is 2018 13 SCC 560, paragraph 33. Two 2018 13 SCC 560, paragraph 33.
Yes.
Question now is whether in the absence of any right in favor of Shikha Mitros, they are entitled to any other relief or preference. In the peculiar fact situations, they ought to be given opportunity to be considered for recruitment if they have acquired or they now acquire the requisite qualification in terms of the advertisement for recruitment for the next 2 consecutive recruitments. They may also be given suitable age relaxations, which has been given to us also, some of us, I would say, who required it, and some weightage for their experience as may be decided by the authority concerned. This is not a case where there is a rule itself. All I'm trying to say, there is a recognition of experience and thereby some consequential benefit which can be given without affecting Article 14, only that part. And then this one. This is this is clear cut 2016 SCC online, Rajasthan 646, paragraph 6 first. Before coming to the facts, it would be appropriate to mention that the concept of equality enshrined in the Constitution of India does not forbid reasonable classification for the purpose of legislation. If any classification is made which is founded on an intelligible differentia, it distinguishes persons or things that are good together from others left out, and the differentia made possess a rational relation to the object sought to be achieved by the statute in question, then that does not offend the concept of equality. The concept of equality does not take away the authority of the state to classify the persons for legitimate purposes. If a law deals equality with members of a well-defined class, it is neither obnoxious nor a denial of equal protections given under Article 14 of the Constitution. Thereafter, my lord, a 5-judge bench of the Honorable Supreme Court in Chiranjit Lad was referred, same page, paragraph 7. I'm not reading it, the last paragraph. Lordship may kindly mark paragraph 7, the last portion in Chiranjit Lal versus Union of India. That's a constitutional bench judgment. After that, ultimately, thereafter, paragraph 12. In view of it, we are of considered opinion that the persons having experience on similar work under the government, National Rural Health Mission, and Medicare Relief Society form absolutely a different category, and the classification made under the proviso impugned is not at all discriminatory. This was upheld by the Honorable Supreme Court. Tell me paragraph. Well, last one, 2021, 15 SSC, 401, paragraph 61. Before that, Lordship may also kindly take paragraph 54.3. Should sorry, 54.3 and 61.
Yes.
And this is directly the question was freshers versus someone who was working. 54.3, should there not be a different yardstick for Shikha Mitros who had been rendering services as teachers as against what could be applied for fresh graduates? Now, in that light, the answer is at paragraph 61. Relying on the decision of the court in such and such, it was submitted that Shikha Mitra who had been discharging their services as teachers could not be put at the same level with fresh graduates having such and such qualifications. In that case, this court was called upon to consider setting aside of certain seats of the state government for in-service candidates in postgraduate courses. It was observed by this court, thereafter this is a quote, and Lordship may skip that and kindly straight to come to last paragraph of the same page. This court was considering validity of certain percentage of seats earmarked for in-service candidates, and it found the classification to be correct, having nexus with the object of ensuring availability of competent professionals in the rural parts of the state. On the other hand, the object of giving opportunities to Shikha Mitros was to ensure that they are given fair chance to compete with others so that the best of the lot would be available to take care of primary educations in the state. In our view, the submission does not deserve acceptance. Question C set out such and such is answered accordingly. Well, these are my judgments on prior teaching experience point. Well, next is having participated. No, having participated. Physical. Well, first is 2019.
Which proposition?
Yes. Well, all of them, they have participated.
And now they question the selection process.
Now
and
they
the
have, Lordship may look at from two views. One is they are questioning the constitutionality. The other view is, while questioning the constitutionality, they are also questioning the method of the recruitment, because the marking was well known to them. They participated. Now they are. So in that context, I want to say, having participated and knowing fully well about the method, now possibly they cannot question it now. In that context, first 2019, 15 SCC 633, paragraph 21 and 22. And 22. Paragraph 21 and 22. First 21. There is one more aspect of the matter which need to be noted. The applicant was well aware that under 30% LDC quota, out of 5 vacancies, 4 are unreserved and 1 is reserved, which was circulated by notification dated such and such. She applied the said bifurcated vacancies and was interviewed on such and such, panel of which was declared on such and such, and promotion was made on same day. She having participated in the selection for promotions under such percentage quota and bifurcations of the vacancies being part of the process of selection, it was not open for her to challenge the bifurcations of vacancies into general and reserved after taking a chance to get selected. In this context, reference is made to judgment of this court in Ashok Kumar versus State of Bihar. Then, my lord, the court, the law on the subject has been crystallized in several decisions of this court. In Chandraprakash Triwari, this court laid down the principle that when a candidate appears at an examinations without objection and is subsequently found to be not successful, a challenge to the process is precluded. The question of entertaining a petition challenging an examination would not arise where a candidate has appeared and participated. He or she cannot subsequently turn around and contend that the process was unfair, or that there was a lacuna therein, merely because the result is not palatable. In Union of India versus Binod Kumar, this court held, it is also well settled that those candidates who had taken part in the selection process, knowing fully well the procedure laid down therein, were not entitled to question the same. But in fact, I would not read the entire paragraph because it is same propositions spread over everywhere. Lordship, ultimately 22 with us, due to above both reasons, are of the view that the tribunal and the High Court ought not to have entertained the scale claim of the appellant. Well, on this proposition, my next is 2013 11 SCC 309. Paragraph 18, 19, 21, 22 and 24. I shall be referring to paragraph 22. I shall be reading 22. Referring all, but not. Well, I am reading only one paragraph, but I am relying the all others also. 22. In Manish Kumar Shashi versus State of Bihar, the court reiterated the principle laid down in the earlier judgments and observed. We also agree with the High Court that after having taken part in the process of selection, knowing fully well that more than 19% marks, this is the, here it is 10 marks, more than 19% marks have been earmarked for viva voce test, the petitioner is not entitled to challenge the criteria or process of selection. Surely, if the petitioner's name had appeared in the merit list, he would not have even dreamt of challenging the selection. The petitioner invoked jurisdictions of the High Court under Article 226 of the Constitution of India only after he found that his name does not figure in the merit list prepared by the Commission. This conduct of the petitioner clearly disentitles him from questioning the selection, and the High Court did not commit any error by refusing to entertain the writ petition. The same proposition. The other judgments on the same propositions is 2017 9 SCC 478. Paragraph 4, 6, 8, 10 and 11. I would be referring all, but I shall be reading only one paragraph, paragraph 11. As far as the present case is concerned, an advertisement was issued by respondent number 6 inviting applications for the post of music teacher in such and such school. Respondent 1 did not raise any objections at that stage that the post could not be filled in by direct recruitment and she should be considered for promotion. Not only that, she is in fact applied for the post and took part in the selection process. After having taken part in the selection process, and being found lower in merit to the appellant, she cannot at this stage be permitted to turn around and claim that the post could not be filled in by direct recruitment. The reasoning of the learned single judge in rejecting the objection is not in consonance with the law laid down by this court. In view of this, we need not go into the other issues raised. The last one is 2022 1 SCC 294. This is by a larger bench comprised of 3 honorable judges. 2022 1 SCC 294, paragraph 35, 36, 37, and 45.
30, please repeat, 35.
35, 36, 37, and 45.
Yes.
Well, I'm not reading it because it is
Reiterating the same thing.
Yes, same thing. But only purpose of this for two, that this matter being even had it been any other matter, maybe I would have brought only one judgment, so that my sentence
Consistent view of the
that I'm not picking up and saying that I got a judgment and therefore I'm placing. No, this is the consistent view. So only that purpose.
কি কথা বলছো ওদিকে? The clock is ticking.
Yes. Well,
30.
I might take just 10 to 15 minutes.
Another 15 minutes.
10 minutes, because I have almost finished. I would wrap up with two things. One is that Orunima, in fact, that I have with me. And I might take just 5 minutes to sum up, and not 15 minutes by clock.
May I request only because I believe all parties are.
1 minute. Tell me one thing. The commission is here. Whether the disclaimer has been published.
Yes.
Or another thing is the substance.
Because this is troubling the court. The time is going. The 31st is the date. Nobody knows which side it will tilt. It involves thousands and lakhs of candidates participating. The commission should keep the data ready. I will require the data, the number of candidates participating, the freshers, the old ones, and everybody. The percentage, how have they fared, and everything. For giving a proper judgment, these data may be required. As and when stages come, these ideas come to your mind. I cannot offhand say, but then since the arguments are advanced, I have to think over it.
That I would be also requesting Learned Advocate General to have the statistics that by percentage wise, for out of total 35,000, how many freshers have got and
Yes.
how many, so that some rough
You will
idea.
not be able to say. The commission is
SSC.
here.
No, sorry.
The commission will say.
I just
If they make it
Correct.
in a tabular form, that
Yes.
in
Correct.
each and every subject
Right,
matter,
right.
give an idea without,
and another
It will be easy.
yes.
Everybody also gets to
yes,
know that
yes.
this is the picture
Picture.
and why this judgment is coming. Otherwise,
Right.
various questions
Correct.
nowadays.
Correct.
Why
Yes,
this?
yes.
Why not this?
Yes, true.
and another thing, substantial amount
Correct.
is taken.
Substantial amount.
Substantial time already taken by the all the
Parties.
parties because if everyone is agreed on it, make it parter only. Otherwise, if
Yes, 100%.
I have
We can't afford to-
mentioned it on the last occasion that the court has consumed a lot of time in this
we would
matter.
be doing an
Assuming
injustice.
the bench
Yes.
gets changed,
Please.
it will be an
Treat it as a
understanding that
partner.
it has been substantially heard by this bench.
Your Lordship,
Now, if somebody says no, it has to go, it
No,
will
no,
go.
no.
Certainly, a court cannot hold on to
Well,
the
I
matter.
want it because I have spent lot of time. I understand the precious judicial. Kindly treat it as a
Judicial hours, valuable, very
Yes,
valuable
yes,
judicial hours
yes,
have been spent on this.
True. So kindly,
I'm not recording heard in part. Let's see what happens.
Lordship can record it. What is the
otherwise, we both the parties agreed, my lord. Or
No,
by
it's not.
consent.
No, it's not both. There are many parties.
The commercial, every party.
There are many parties. I'm not recording it formally,
No,
but then let it be
in case anything happens, or
considered.
discussed,
Yes.
uh,
In case there is change,
Yes.
in case there is no change, it's going on. I do not know whether there'll be a change or not. Nobody knows.
Still,
One indulgence I will be playing because I am I am in a situation that possibly tomorrow my turn will come. But you know, I have fixed two matters tomorrow, at least 2 weeks back. One is fixed at 2 o'clock, the other is fixed at 3:30.
morning, morning,
I should be like, inform the court that
I'm-
tomorrow,
Difficult for you.
because I cannot finish in a half. Otherwise, you know, I would have started of course, the other business.
Other matters have to be given some amount of time. The entire second half is consumed here.
Could your lordship will not accommodate me in the day after tomorrow?
Let us see. Day-to-day hearing will be
Yes.
possible or
If the
not.
situation comes that
Yesterday, I didn't take up this matter. I kept at least one day in between
Right.
to take up other matters.
Well, in one matter, this opposition, there was a little delay, so kindly one line.
I will condone the delay.
No, there is.
I
no-
will not take it as a delay. I'll permit
Yes, that.
those
That
documents
is in item
to
60.
come in.
60?
1 minute. Let me first
Yes,
think
yes,
as to when will be the next date.
না, 61 টা
Item 60? My mind and the calendar
Yes.
are not in the same line.
OMR published ইস্যুটা কালকে আছে না
Uh,
my lord, item number 61, that is Moshumi Mondal matter, my lord. There is a 261 Moshumi Mondal that went up to the Supreme Court, my lord, and Supreme Court freshly is taken up by this bench, my lord. Till date, already, my lord, pass an order to publish the 2025 OMR sheet. Till date, they not publish it, my lord. Same prayer in Moshumi Mondal also, my lord. It will be kind enough. The matter will came up tomorrow, my lord. That matter, my lord. It will be kind enough posted this Moshumi Mondal item number 61 tomorrow, my lord, along with others, my lord, prayer.
all right, if there's an exception, the court will certainly hear. Please come. Are you a party in Lubana?
Yes.
Rubana,
Because I did not see your appearance on the last occasion. In
Rubana,
Lubana, you are not there.
Rubana, I have
Right.
not.
All right.
I mean,
I indicate one thing, my lord. Lubana is filed because that having participated and rule can't challenge, but Lubana is filed much prior. Just immediate framing of the rules. Lubana and Mosumi Ghosh.
Are the first matters?
Yes, madam. Lubana and Mosumi Ghosh, both the Ghosh Das, both the matter filed just immediate after the publication of the rule, my lord.
Lubana was filed at the time of Odunima's time. My lord, Odunima was heard, but Lubana was left.
All right.
Lubana and Mosumi Ghosh Das, both the matter, my lord, filed at that point of
Moushumi
time.
Ghosh Dash, which item is this?
Item number
number 62.
62.
62. Yes.
And there,
12,000.
thereafter, my lord, Bhim Sarkar and Chaitali.
That is after fresh candidate. ঠিক আছে। Hard submission recorded in Lubana. এই যেটা হচ্ছে 56. Hard submission made on behalf of some of the job losers, untainted job losers.
Not specifically attended.
Who participated in the second SLST 2025. Stop. Fix the matter for further hearing on. I'll take it to the 6th of January. Yes.
Then make it for one line, one make it patad, my lord. My lord, with all the parties, my lord, agreed on that one. Because
Don't worry, it is part heard, but then I'm not recording it.
then, my lord, item number 61. My lord,
এটা কে দিয়েছে? এটাতে 56 এ নেই, সেই জন্য দেয়নি।
Side পুরো বাঞ্চটা।
That can be tagged together.
my lord, they are in
Lubana?
my matter.
Let the petitioner say,
Marat-
you then
My matter.
respond whether they are in the same lines or not.
Mother, I just to give the 56 Lubana Parvin,
Hmm.
59 Bhim Kumar Sarkar.
Before that, 58 also.
That is not my matter, so
No,
I
that's why, but
could.
I'm,
Shishir Rahul.
1 minute. Shishir also.
yes, but I'm appearing also.
Acha, tale 56, 57.
No, Mother, 60 except 61. Except 61. 61, Mother, put it tomorrow, Mother.
All right, 56, 57, 58, 59, 60 and 62, except 61. I'll put it in one order in that case.
Affidavit.
Some of the job losers will. All right, so that will.
Well, 63 also where
আপনার সেই আরেকটু proper দিকে পাঠিয়ে
মানে
দিকে
পিছনে আমাদের candidate। বিশ্বজিৎ আছে।
ওরকম ভাবে কি রকম ভাবে যে হয় না।
Up to 62 except 61.
Up to 62 except 61, one item, one order is being passed, which
Yes.
will cover all.
তো কেন হয়েছে?
6th of January 2026. You have difficulty this week and then the court's time may not permit. That is the reason. Now 61 will be there in the list tomorrow.
Tomorrow. Yes.
All right. And 63 onwards, let it remain in the list as and when.
63 is identical.
Oh, acha,
63, that
63,
opposition.
এটা তো
63, I am for the
order
petition.
record. Which applicant?
Applicant number 2, can 2.
Acha. Affidavit in opposition filed on behalf of the applicant in can 2 taken on record. It will be open for the petitioners to file exception to the same. Prior to the adjournment. Item numbers.
এই দিবে কপি দিও যদি আমাদের এবার SSC
Actually,
58, 59 and 60.
Filed by the commission. Please circulate copies.
and I keep 63 also with this bunch.
পাঠিয়েছি পাইনি এরাও পাঠিয়েছি
63 বলছে এই বাঞ্চে
63
নেওয়ার
also
জন্য।
keep.
Well, 63, well, I have got a petitioner. This issue is, my lord, the
11th.
60. My lord, the
Different issue.
yes. 63.
Well, this is also regarding giving of 10.
63 is, my lord, the 10 marks, or that 9-10 school
Are you the
teacher.
petitioner in 63?
Yes.
Let it be separate.
He is the petitioner in
It is
63.
63.
This is also
Let
rule
it be answered.
9,
There
10,
is
11,
no
12.
challenge, but then whether 9, 10 experience.
Yes. That is.
That
For 11, 12.
Sir, he has not
This
challenged.
issue has not been challenged in the other ones.
বলে দিন আমারটা
63 is separate. Yes, sir.
58.
64 onwards will remain in the list as it is. Your matter has been tagged up.
58 and another is not in the list that I had done yesterday.
Let it come. I am keeping matters in a staggered manner, so everyone can come in.
I don't know different issue আছে
All right.
Okay.
All parties.
Respondent. নাম্বার দেখে
দিয়ে দিন।
61 টা লিস্টে কালকে থাকছে and 63 না 63 অর্ডার হয়েছে। হ্যাঁ
এইটা না
হুম।
বানাতে রাখ
If you want, কিন্তু তাহলে তো ওর ইয়েটা সাবমিশনটা তাহলে কোথায় রেকর্ড করা?
মৌসুমী মন্ডলের order।
63 opposition has been filed. You can file your reply. Whoever the petitioner is, you can
Yes.
file your reply. I'll fix it on the 6th of January.
Yes.
Exchange all your pleadings.
না আমার যেটাতে দিয়েছে